In a relatively high number of cases, the ICC prosecutor has charged individuals for crimes against humanity involving and war crimes involving sexual and gender-based violence and crimes. This, however, has resulted in a limited number of convictions and sentences. In the very first case brought by the prosecutor to the judges, the case concerning Lubanga Dilo, militia leader operating in the Democratic Republic of Congo, the charges were of war crimes in the form of enrolling, enlisting, and conscripting, and using child soldiers in hostilities. There was also evidence that Lubanga and his militia were involved in the commission of other crimes of rape, sexual enslavement, and other gender-based violences. But these facts were not included in the indictment for some reasons, to protect witnesses, they say, but also probably to achieve a quicker conviction, perhaps. This decision of dropping these charges from the indictment and from the trial was received with a lot of criticism, also by some of the judges, and particularly affected the female child soldiers because they were not even acknowledged as child soldiers.
Sexual crimes were mentioned instead in the indictment against Ntaganda, another warlord based in the Democratic Republic of Congo. Rape, sexual slavery, and outrages upon personal dignity were charged as both crimes against humanity and war crimes. Also, in the Ntaganda case, however, the outcome is disappointing. On one hand, sexual crimes were not eventually found proved beyond any reasonable doubt. On the other hand, the court did not consider Ntaganda liable for rapes and sexual violence committed during the pillage of the Bororo village by his troops.
Probably the most momentous trial in which sexual and gender-based crimes were included in an indictment before the ICC was the Bemba case. Bemba was prosecuted and tried by a chamber of the ICC and eventually convicted for war crimes and crimes against humanity, based on the rule of the ICC concerning the command responsibility, because he failed to prevent and punish his troop who committed this widespread and systematic rape. This decision of the trial chamber in 2016 was a breakthrough in the jurisprudence of the ICC because for the first time this command responsibility rule was used in the case of sexual and gender-based violence. The approach of the court in this case marked an advancement compared to the Ntaganda case, for example. The appeals chamber in 2018 decided that a commander based in Democratic Republic of Congo could not held responsible for crimes committed by his subordinates in Central African Republic and acquitted Bemba. A number of victims, female victims of these rapes, were participating in the Bemba trial, and because of this acquitment, no reparation was eventually awarded to them.
A wide range of charges for sexual and gender-based crimes were included in the Ongwen case. Ongwen was members of the Lord's Resistance Army in Uganda. Charges included forced pregnancy and forced marriage as part of a systematic and institutionalized practice of abducting young women with the aim of forcing them in an exclusive conjugal relationship with the commanders of the Lord's Resistance Army. In this case, the prosecutor stressed that forced marriage, punished under Article 7, letter H of the statute about other inhuman acts, constituted a gendered crime. Indeed, it may involve not only repeated rape, but also imposed forced domestic duties and social responsibilities. And in some cases, this included also pregnancy and motherhood. The court has not yet issued a decision on this case. That is, the trial is still ongoing.
Sexual violence can be committed also against the male, of course. A turning point in the prosecution of these crimes was the Ntaganda case. Bosco Ntaganda was involved in violence, in conflict, in particular in some attacks in the province of Ituri between 2002 and 2003. In 2019, Bosco Ntaganda was found guilty of crimes against humanity in the form of rape, sexual slavery, including also rapes committed against men and boys. The defense raised the point that violence, rapes, for example, committed against members of the same armed group of the accused cannot constitute war crimes. But the appeals chamber rejected this interpretation. The charges were confirmed, meaning that rape and sexual enslavement committed by members of an armed group against child soldiers belonging to the same group can indeed be war crimes and prosecuted and punished as war crimes.
The ICC also successfully charged Al-Hassan, who was an alleged member of the Ansar Eddin armed group operating in Mali and affiliated to Al-Qaeda. The pre-trial chamber found it reasonable to believe that Al-Hassan was responsible for several crimes against humanity and war crimes, including forced marriage, forced pregnancy, cruel treatment, torture, outrages upon personal dignity, rape, and persecution on religious and gender grounds. The charge of persecution on gender grounds has no precedent in the jurisprudence of the ICC, because it was the first time that it had been put forward for confirmation in a proceeding before the court. The other case in which the prosecutor attempted to include this kind of charge, that was the Ntaganda case, the charge of persecution based on gender grounds was dropped. In this case, gender persecution described the situation of women and girls during the occupation of the city of Timbuktu by the Islamic extremist groups. There was a very strict control over almost every aspect of their private and public life, and deprivation of fundamental human rights. The hearing on the confirmation of the charges has just been held in July 2019.